Good afternoon, and welcome to the third Human Rights Conversation in Times of COVID-19. I'm pleased to introduce Dr. Marie-Luce Paris, who is Associate Professor at the University College Dublin Sutherland School of Law. Marie-Luce is the Academic Director of the UCD Center for Human Rights, and she took the initiative of this series of human rights conversations. Her primary research interests lie in European human rights law, comparative and European public law, and French law. She has published widely in these areas, including 2 edited books on comparative constitutional law and French constitutional law. She's currently the principal investigator of an IRC Ulysses project on deliberative democracy in light of the French and Irish constitutional experiments in collaboration with the University of Aix-Marseille. So today we'll talk about legal actions against the state in the context of COVID-19. And in particular, we're going to draw a comparison between Ireland and France. So first of all, Marie-Luce, I would like to ask you, so could you please set out briefly the context of these legal actions against the state?
Certainly. Thanks, Edardo, for this nice introduction. So about the context of these legal actions, we all realize now that the COVID-19 crisis has had a profound effect on the way we as individuals interact with one another, on the way we interact in our communities, and as citizens we interact with our in society. And so the crisis has also had a great impact on the way our institutions and government work. So the way our respective governments have reacted during this pandemic is by adopting emergency legislations. And these legislations were adopted just a few weeks after the World Health Organization declared on the 11th of March that we were facing a state of pandemic. For example, the UK passed the Coronavirus Act of 2020 on the 25th of March. And in the Republic of Ireland, 2 acts were adopted in quick succession on the 20th and 27th of March. The first is the Health Preservation and Protection and Other Emergency Measures in the Public Interest Act, and the other act is the Emergency Measures in the Public Interest COVID-19 Act. So, and in France, it was the law of the 23rd of March, which was followed by a number of ordinances, more than 60 to date. Ordinances are executive measures, so taken by the executive power, and these ones were, in France, they were taken between March and June. And I must say as well, in the context of Ireland, there were also statutory instruments, a number of them, which accompanied the legislation. So, and ever since the adoption of these exceptional measures, well, the governments in question all over Europe, they have been under watch. And we can understand that because while these emergency measures have generally been well received and complied with by the majority of the population, we know that they have imposed a level of restriction on citizens' rights and freedoms, on freedom of movement and freedom to trade in particular, that has not been observed in recent times. So, and generally, more generally, the governments have been criticized, some of them for handling the way they have handled the crisis, especially in their role of ensuring the protection and the preparation of the health system and health workers. So this is in this broad context that legal actions have been mounted against a number of governments and their administration. And in this presentation, in this conversation, I put, as you said, into perspective the situation to date in Ireland and in France.
Thanks, Marie-Luce. And in particular, what legal proceedings are we talking about?
So there are different kinds, and I will explain that in a moment. But we can say, now that the contrast between Ireland and France is quite interesting. While in Ireland, the Irish government has to face one legal proceedings, one case. for constitutional infringements, the French government has to respond, and is still, yet to respond on different fronts, including on constitutional proceedings. So, well, if we start with the Irish case, we know that the measures taken under the COVID-19 laws or emergency legislation, they have apparently been successful in curbing the spread of the virus. They have been widely supported and implemented by the people, but these measures, as I was saying, have had a detrimental effect on the Irish economy. With significant job losses and closure of businesses, and also, I mentioned before, on personal freedoms. So a priori, legal actions against state measures would not have appeared unlikely if they were to be based on constitutional rights, property rights, and the right to earn a livelihood in particular. So it was no surprise that a constitutional challenge was mounted very quickly after the adoption of the emergency legislation. And this particular constitutional challenge was prepared by two Irish journalists, Doherty and Waters, against the Minister for Health. It came in mid-April, while the country was in full lockdown, it's important to say, and the full lockdown was between 27th of March and 5th of May. So what happened in the case is that they applied for leave before the High Court, and they sought to bring judicial review proceedings against the COVID-19 laws and regulations on the basis of their unconstitutionality. And they argued that these laws were incompatible with a number of provisions under Article 40, so the personal rights of the citizens. They also made reference to the unenumerated rights, the right to inviolability of the dwelling, the right to assemble peaceably, as well as the right to family life under Article 41, and the right to practice religion under Article 44.2. So the result of this case, the outcome, is that it's a scathing ruling by Justice Menon on the 30th of May. It did not accept any of the arguments made by the applicants. I'm not detailing here the whole ruling, but a point of note is that the judge certainly did not well receive their most controversial argument, which was the following one. So the applicant said that, and I'm quoting, "These draconian, regressive, and unnecessary governmental measures were acted upon some kind of fraudulent science and revealed the arrival of a police state which could be paralleled with Nazi Germany." Well, the judge made it clear that while the applicants had standing in the case, because the restrictive measures were meant to affect everyone, including the applicants, everyone residing in the state, the applicants completely failed to make a properly argued case, which was backed up by relevant facts. And in their case, in their application, the applicants also contested the number of deaths and the number of contaminations. So it was a bit strange. So at the end of the ruling, the judge noted that the applicants had, and I quote again, "no medical or scientific qualifications or expertise." And he said that they could not rely on unsubstantiated opinions, speeches, empty rhetoric, and a bogus historical parallel to substitute for facts. Curiously also, the applicants challenged the steps taken and the procedures followed by the Oireachtas, which is the Irish Parliament, in enacting the COVID-19 laws. And that was not accepted either by the High Court judge. He declared that the complaints about the procedure followed in the Dáil and Sinead, which is the Houses of Parliament, were not justiciable, and that the court could not hear such complaints because obviously that would breach the separation of powers principle. But this is interesting to know. This argument is interesting because it shows from the part of the applicants, apart from an obvious lack of preparation or amateurism, that they envisage their challenge to the COVID-19 laws as a full action against the political institutions. And this is kind of relevant as regards to what has happened in the French case. to which I now turn. For the French situation, at the moment, the French government has to face multiple legal challenges, some of them having found a resolution quite recently at the end of June. And in this case, there are two types of legal challenges. The first type is similarly to the Irish case. It's based on constitutional grounds. However, obviously, the French approach has been different for contextual and procedural reasons. So I'm starting with this constitutional challenge now. So instead of a sweeping challenge, like in the Irish case, the constitutional complaints have targeted specific aspects of the legislation, of the COVID-19 legislation, and especially as regards criminal law from constitutional challenge. So it could be contested or challenged a posteriori. And this is what happened with the a posteriori review, which is laid down under Article 61(1) of the Constitution. And I mentioned that because it's this famous QPC procedure, which is quite a new thing under the French system. It's a 10-year-old procedure, and the QPC stands for Question prioritaire de constitutionnalité. So it's the procedure for priority preliminary ruling on an issue of constitutionality. If you want a little bit the equivalent of Article 34 under the Irish Constitution. And on the 26th of June, the French Constitutional Council, which is the French Constitutional Court, delivered its ruling on precisely this legislation. The name of the decision is Repeated Breaches of Lockdown, and it validated the legislation, and in particular the délit de violation du confinement, or criminal offense of violation of confinement.
Oh, this is extremely interesting. And could you tell us a bit more about this constitutional challenge before the Constitutional Council? So was it eventually successful? I mean, of course, for the applicants, or?
Well, I must say first what was really at stake in this challenge, what was incompatible with the Constitution or argued to be incompatible. What was at stake was this particular offense, the criminal offense of breaching of lockdown. And the fact that this offense, which was inserted in the Public Health Code, was allegedly lacking in precision and clarity. And this was the argument. Because, well, among other things, this new offense provided that the person was fined to more than 3 times, for violation of the lockdown within 30 days, was liable to a sentence of 6 months in jail and a fine of more than 3,000 euros. Well, that's quite harsh, especially if you don't know what it means, the offense. And especially the more than 3 times in 30 days part was problematic, not very clear in the mind of the French citizens. So a number of lawyers all over France, they asked a number of very legitimate questions, not only this one, but other questions. And again, I'm going into a bit of the details of the case, but normally the legal deadline for contesting a contravention is 45 days, which can be extended to 90 days in case of emergency legislation, and contravention is the first degree of a criminal offense under the French system. In this case, the new offense of violation of confinement provided for a repetition of the breach more than 3 times in the 30 days. So the question then was, what would happen to a person sentenced to prison if one or all of his tickets for infringement challenged within the statutory time limits were cancelled? So what about the situation of this person who would be in jail? There were other questions. There were other questions, more general questions. For example, in the legislation, the lawyers were wondering what is a compelling family reason which can justify, going out of your home, or what is the purchase of first necessity, and their practical implications. here I'm drawing from the questions that were asked, to the referring court. So all my examples are actually drawn from these questions. So they asked, for example, would an outing to get a pregnancy test or hygienic protections be considered as complying with the law, or on the contrary, be susceptible to verbalization? So they were very mundane questions, but very important questions. For the French citizens. So in the joint ruling, the French constitutional judge ruled that the legislation complied with the constitution. There was no lack of precision. It was clear enough. So there were these verbalization of individuals repeatedly breaking lockdown rules were neither imprecise nor ambiguous. And the judge added that in adopted these laws, the legislature defined with sufficient precision the essential elements of the prohibition of leaving one's home when a state of emergency is declared. So in that sense, the applicants were not successful because, no legislation was struck down, but they were, nevertheless, it can be said to be a success in the sense that there was a necessary clarification, which was, brought about by the judge. And indeed, that was an important decision because during the French lockdown, the full lockdown from 17th of March to the 11th of May, more than 1 million fines were issued for more than 20 million checks, not verbalization, but checks. And these were figures from the Minister for the Interior. So if we compare the two situations, the two challenges, and I'm aware that this is a very broad brush of a comparison, but we can see that while in the Irish case, the court really bluntly rejected the applicant's claim because it was a very poor rhetoric with unsupported arguments, a very poor claim, poorly drafted. Well, this seems to have been quite the opposite in the French case, because the Court of Cassation, which is the highest civil and criminal court in the French system, decided to refer to the French Constitutional Court precisely because the questions asked by the lawyers were serious enough, which is a criterion to make a reference to the Constitutional Court. So these questions were regarded as serious enough to refer the case to the Constitutional Court. So. And indeed, the allegations were actually made by a team of very well experienced and some of them very well-known lawyers about what they qualified. And again, I'm quoting one of the lawyers here. He said that it was a badly crafted offense tinkered on a corner of the table by the French government. So still, the result is the same. The COVID-19 laws and the governmental measures are not contrary to constitutional rights.
Oh, thanks. This is extremely interesting. And there is also in parallel another kind of challenges that the French government is facing at the moment. Could you tell us a bit more about these other kind of challenges?
Yeah, that's another part, and the second type of legal challenges that the French government is to face contains, if you are a more political element, and it would be interesting to see the outcome. So it's about more than 80 complaints that have been filed before what we call the Court of Justice of the Republic. This Cour de Justice de la République, it's a special court which decides on the criminal cases, criminal liability cases for the offences that are committed by members of the government while they are in office. So I must say at this stage, to understand a bit the context of this court, it was established in 1993. After the scandal, the dramatic contaminated blood case, contaminated by AIDS. And this case, at the time, in the late 80s, beginning of the 90s, involved a number of politicians and top civil servants. And I must say, among the politicians were the current president of the Conseil Constitutionnel. And I must say as well that AIDS is another pandemic that we're still facing. But that was when it was established to to deal with those cases. And the proceedings before the Cour de Justice de la République can be brought by individuals or groups of individuals when they claim that their rights have been infringed by a government official while he's performing his or her duties. And it's interesting in that case, in the COVID crisis, to see the variety, the diversity of groups that have challenged the government measures. So obviously you have doctors in hospitals for the lack of masks, for example. They actually mounted formed a case. Trade unions as well, other individuals. So for acts relating to the endangerment of the lives of others, non-assistance to persons in danger, and even manslaughter. So these claims are meant to make the government, mainly the Prime Minister and the Minister for Health, because they are the ones who are targeted, they are meant to make the government accountable for the management of the crisis. And especially as regards the provision of PPE, or personal protective equipment, and the mask in particular, because as you know, in France, the provision of masks has been a big fiasco. There were enough of them a few years back, but they decided for some reason to destroy the stock of masks, and there was a shortage at the time of the crisis. So it was dreadful.
Really unbelievable. And do you think that these actions will be successful and that some ministers will be convicted, or?
I don't know. I don't think so. I think that the outcome of these actions before the Cour de Justice de la République is likely to be very disappointing. Well, assuming that these actions passed the admissibility stage, which actually they did. They have passed, sorry. They have passed because last week they admitted the claims. But you have another filter mechanism. So before it reaches the court itself, there is an inquiry committee. So that would be a further hindrance. And this filter mechanism is in fact in place to avoid that this Cour de Justice de la République is used as a political weapon. Because I told you it contains obviously a political element. So they have all these stages in the procedure. So I think there will be, it will be a further hindrance for what I believe will be an elusive finding of ministerial liability.
No. Extremely interesting. And what can we conclude from this analysis? What are your thoughts?
Yeah, so I said before, it's a very broad brush of what has happened so far in both jurisdictions. So it has not to be taken as, a complete picture. But I would say that we might think that it was not the time to stymie government action, especially when we were at the deep end of the crisis. Okay, but still, these legal actions show the robustness and the reactivity of our respective judicial systems and the commitment to the rule of law. And this is especially true when the courts themselves, all kind of courts, the court system, if you want, had to adapt their way of working, and especially the public hearings, because there was in some circumstances no public hearings. And that was, by the way, one of the arguments in the Irish case that they had, which I didn't mention, but that was in the case. So anyway, in these unusual times, these legal actions appear as a healthy reaction to public concerns, and especially in the French and Irish cases, it has been significant to control the action of the government, because at the time the political context was quite tensed. For different reasons, but that was in both countries. Because in the Irish case, during the pandemic, Taoiseach Varadkar was in fact formally carrying out his duties as Taoiseach with his government, because there was no government yet formed during the period, because the successor had failed to be appointed following the February general elections. And on the French side, it was a kind of a different problem. President Macron and his government, headed by former then Prime Minister Philippe, they had to deal with the crisis literally in between two rounds of local elections. The first round was very controversial in March, And the second was just happened at the end of June, and in between, in these two rounds, the presidential majority was in difficulty in many municipalities, and they took a heavy defeat on the 28th of June. So that was important to actually make sure that there were legal checks on the governments. Now, even though the pandemic has been slowing down in Europe, we can say, even if there are new clusters and new concerns, it's likely that the recent surge of new contaminations will lead to other measures, to what I call an Act 2 of governmental measures, and hence potentially other legal challenges. So I would say that it's important that we take stock of what has happened so far in this regard, and the government will certainly benefit from knowing how its action has fared in what has been the Act 1 of the crisis. And this, in turn, will ensure that the proper balance is maintained between the imposition of further restrictive measures and the protection of citizens' rights and the implementation of the rule of law in general. And this is what one of the French lawyers was referring to in his submissions to the French Constitutional Court. And I'm quoting here, he said, "You are not only judging the past," meaning the former, the preceding legislation, "but also for the future. As he noted, the repressive system remains."
Really like a thought-provoking quotation from the French constitutional judge. So many thanks, Marie-Luce, for this extremely interesting analysis of legal actions against the state in times of COVID-19. Thank you for this insightful comparison between France and Ireland. Thank you very much.